Good afternoon, everybody. Thank you for joining us today for the 6th webinar in Conn Maciel Carey's OSHA webinar series. We set about to put together the agenda for the entire year back in October and November last year, and just sort of guessed that it would be right around June that OSHA was going to finalize their injury and illness record-keeping ESubmission Rule, and it turned out that we were pretty accurate in our guess. That right at the end of May, OSHA issued a final rule of great consequence for most employers in the U.S. And that's why you all are here today, is to, I guess, learn about this new rule, what it means for you, whether it applies to you, when the important dates are, and what the potential consequences are of this new rule. So we're going to cover today OSHA's Injury and Illness Record-Keeping Electronic Submission Rule, as well as one other record-keeping rule that's moving its way through the rulemaking process. We probably won't see it by the end of the Obama presidency, but OSHA is pushing hard on that, and that's the rule to change the statute of limitations. But the majority of our discussion today will focus on the electronic record-keeping rule. So the faceless voices that you're hearing, I recognize most of the names of the folks who have dialed in, but some of you, we're e-meeting or webinar meeting for the first time. My name is Eric Conn. I'm one of the founding partners of Conn Maciel Carey, and I chair the firm's National Workplace Safety OSHA practice group. My practice focuses on all aspects of workplace safety and health law. I represent employers in incident inspections, incident investigations from a broad range of agencies, but primarily OSHA and the state OSHA programs. We also get involved in EPA matters where there's an overlap with workplace safety, as well as the U.S. Chemical Safety and Hazard Investigation Board. And we were very pleased earlier this year to add a couple of really stellar mine safety and health professionals to our team as well. So we really do have the full range of safety and health covered. I also work on all matters of litigation with OSHA, from contesting citations to criminal referrals and investigations to criminal prosecutions. We also work with our clients to develop safety and health programs, to audit safety and health programs, and to provide training and compliance counseling. I'm joined today by my partner, Amanda Stratus Walker, and I'll have her introduce herself a little bit.
Good afternoon. Hi, my name's Amanda Stratus Walker, and I work with Eric Conn and do just about everything, same practice area as Eric. I've been working with Eric for a little over the past 5 years, and I actually might be one of the few practitioners, if not the only one, who can say that my entire legal career has been dedicated to OSHA. Right after law school, went to the Department of Labor in the Assistant Secretary's Office of OSHA, and then moved over to the Solicitor's Office, focusing on occupational safety and health compliance in all aspects, the enforcement side, the policy-making side, and have continued to do that in the private sector since making that transition back in 2009.
All right, so what Amanda and I are going to be talking about today primarily is OSHA's new Injury and Illness Electronic Submission Rule. So we'll cover what the rule actually requires and the deadlines and who it applies to and all that fun stuff. But then we're also going to cover a provision or a set of provisions in this rule that sort of came to be late in the process. There is a substantial amount of whistleblower retaliation components to this same record-keeping rule, and Amanda's going to cover those in some detail. And then finally, time permitting, we will cover OSHA's other record-keeping rule that's making its way through the process, and that is to amend the statute of limitations to allow OSHA to cite record-keeping violations for 5 years rather than 6 months. So let's jump right in. The rule that I've been referring to is the electronic record-keeping rule, electronic data submission rule, lots of different names out there. What OSHA called it formally was improved tracking of workplace injuries and illnesses. And this has become a final rule. I'm seeing somebody report that they're not hearing audio. Hopefully that's a unique problem, but if that's the case, there is a dial-in number that should have gone with the invitation, or you can get the audio through the computer. But if you're not hearing this, you're not hearing those instructions, so hopefully this is a one-off problem. Okay, So talking about OSHA's improved tracking of workplace injuries and illnesses. And there is a new final rule that was issued May 12, 2016, published in the Federal Registry, that vastly changes the way employers handle their injury and illness record-keeping data. Historically, this data has been really an internal matter. You keep your 300 log over the course of the year. You're adding injuries and illnesses to it that are recordable, but throughout the year it's kept in your HR manager's office, your safety director's office, whoever is the record keeper. And then for a brief period, a few months at the beginning of the following year, you post your 300A for your employees to see. Employees, if they want to access a copy of the 300 log or the 300As, can request a copy of that. But otherwise, unless you are engaged in an OSHA inspection, or unless you are asked by the Bureau of Labor Statistics or OSHA to participate in an annual survey, which is a very small group of employers nationally, those logs and that data is your internal records. And you can use it to learn trends and patterns and things that you might want to change about your equipment, your work configuration, or your work tasks, and you can track it and learn from it internally. What this new rule does is change this from an internal record-keeping process to a very public record-keeping process. And from the starting point, what this rule does is require large employers, defined by OSHA as establishments with 250 or more workers, requires them to submit on an annual basis to OSHA their 300 logs, their 301 incident reports, and their 300A annual summaries. For establishments with 20 or more workers in high-hazard industries, certain designated high-hazard industries, those establishments must annually submit to OSHA only their 300A annual summary. So now, instead of just keeping this data internally and using it for your own internal purposes, you're going to be submitting it to OSHA. That's step one. So it's going outside your doors to our regulator, to OSHA. Now, first let's talk about what these definitions mean. What's a 250-plus establishment? What's a 20-plus establishment? One of the most common questions we got right after the rule was released was, does this mean that if my company-wide I have 250 or more employees, I'm submitting my injury data for all of my facilities, or does this apply only to the individual workplaces? And the rule is that it applies to the establishment. An establishment is defined by OSHA in the Injury and Illness Record-Keeping Rule to mean a single physical location where business is conducted or where services or industrial operations are performed. So an establishment is each of your individual facilities, each of your individual stores, each of your individual manufacturing locations is its own establishment. And the rule applies by establishment. So if you have, 3,000, retail stores around the country, but only 16 to 18 employees at each of those establishments, you would not be covered by this rule. It's not the total number company-wide. It's the number at each individual establishment that triggers the requirement. So by tying this rule to individual establishments, what employers must do to determine whether they are covered by the rule and what they're required to do under the rule, you have to look location by location and determine how many employees do I have at each location, and is that number of employees more than 20, or 20 or more, I should say, and is that number of employees 250 or more at that specific establishment? If the number of employees at the individual establishment is in that 20 to 249 range, then you must also assess whether that establishment is covered by the definition of high hazard industry in the rule. And we'll talk about specifically what industries are covered by that, but it's based on your days away, restricted and transfer injury rate, your DART rate, not yours, but your industry's DART rate. So the applicable employee count, who counts among those 20 to 249 or 250 plus, it is the total number of employees at the workplace at peak employment during the year. So it's not the total number of employees you've had over the course of the year. For example, if you've had a fair amount of turnover and you ultimately got to 30 employees, if you count all of the employees who were not working in parallel with each other, that's not how you count it. You count it by looking at peak employment, the highest number of total employees you had at at any one day during the year. And that includes temporary employees, seasonal employees, and part-time employees. So a couple of questions coming in here. A very good question. Is this the same if I have 3 separate addresses all reporting to a central office within a 6-mile area? And there is a provision in the record-keeping rule that allows you to use a central record-keeping location for various different locations nearby each other. And the way I would view this is it says establishment, but I would view it as the 300 log, because you're looking at things like your DART rates will trigger the reporting requirement if you're 20 to 249, and the DART rate is based on the total number of hours worked and your days away restricted transfer hours. So in other words, you're going to be counting the total hours worked at those 3 different establishments all on one log, and identifying a DART rate for that log. And OSHA is using DART rate here to determine whether somebody or whether some industry needs to report. I think it would work that way. I think the concept would be, if you're keeping one log, OSHA is viewing that as one establishment. That's how I would probably treat it. I'd want to look into that a little bit more, but very good question there. So what are these so-called high-hazard industries? This was an interesting issue through the rulemaking process that we commented on behalf of a couple of different associations. But OSHA proposed to set the average DART rate to be a high-hazard industry. That industry has to have an average DART rate of 2.0. And to give that some perspective, the national average DART rate for all employers across all industries is 1.8. So it's essentially right at average. So to me, obviously defining these as high-hazard industries, but setting the DART rate right at the national average is not a very fair description of high-hazard industry. These are more or less average hazardous industries that have been swept into this rule. And to give it some even more perspective, this is not the first time that OSHA has defined a high-hazard industry. OSHA has for many years operated a site-specific targeting inspection program. And this was, for many, many years, the biggest programmed inspection program that OSHA has. So if you've not had an incident, you've not had an employee complaint, you may still get inspected. If you are in a high-hazard industry, you're just thrown into a big hat, and if your name gets pulled, you get inspected. The threshold that OSHA set for high-hazard industry in the SST was 3.6. And that makes sense. It's twice as high as the national average DART rate. But for purposes of this new reporting rule, OSHA has set that threshold very low at 2.0. And as a result, it swept in a lot of industries that we would not traditionally think of as high-hazard industries. So this is a list straight out of the rule of the industries that are in the NAICS codes that meet that 2.0 or higher DART rate. And I highlighted in orange some that I thought, did not seem intuitive to me that these would be considered high-hazard industry. Wholesale trade, furniture stores, grocery stores, school and employee bus service. I thought there was one, cable and subscription programming, lessors of real estate, general merchandise stores. These just don't jump out at you as truly high-hazard industries. But these are the industries that meet that 2.0 or higher industry average DART rate, and so they are swept into the category that if you're in that industry and you have 20 to 249 employees, your reporting obligation, you have the reporting obligation to submit your 300A data for all of your establishments that meet that criteria. And these would be, again, this is by establishment, not by company. So if your establishment is in one of these, to be clear, it's not about DART rate for your facility. It's about DART rate for your industry. So if your individual facility is has a NAICS code because it's part of an industry that meets one of these DART criteria, then you have the obligation to report. I know it gets a little confusing here. I confuse myself on this issue. But even if you are in a quote-unquote high-hazard industry, but you yourself have a very low DART rate, that doesn't matter because it's not about your individual performance. It's about whether you're in an industry that's required to report, if that makes sense. I got a handful of questions on that subject, so I wanted to make sure that was clear. And what OSHA has done here is they set the DART rate average at 2.0, and then they evaluated it against known public industry average DART rates. So this is, as I understand it, a complete list of industries that are covered by this rule in the 20 to 249 employee range, or establishments with 20 to 249. So I don't believe that there is analysis required by individual employers about whether your industry DART rate meets that 2.0 threshold. My understanding is OSHA has done that analysis and listed those industries, and I've pulled straight from the rule the list that they've published online, and this is what I believe is in there. So what's the consequence of this rule? And to make one last thing clear, because I know this gets muddled about the DART rate and the average rate and this, that, and the other, if you have an establishment with 250 or more employees, it doesn't matter what industry you're in. It doesn't matter what your industry's DART rate is. If you're 250 plus employees at an establishment, you are required to report the data regardless of the industry that you're in. The only exception to that, and of course the only exception to all of this, is if you are in a NAICS code covered industry that is not required to keep records at all, then this rule doesn't apply. The parts of the rule we're talking about now don't apply. So, what are the consequences of this? What do we expect to see happen in terms of numbers of employers who are interacting with the government with their injury and illness record-keeping data? Here's what we expect to happen. We think that this rule is going to quadruple the number of employers required to submit injury data to the Department of Labor. And here's how that counts. Here's where those numbers come from. Historically, under the Bureau of Labor Statistics and OSHA's annual injury and illness record-keeping data survey, they would send out requests and require employers to submit, certain employers to submit their injury and illness data on an annual basis. And it was not the same employer every year. Different employers were invited or required to participate in this survey. And so historically, they were collecting data from about 160,000 establishments with 20 or more employees, and about 38,000 establishments with 250 or more employees. And OSHA's projection is based on their understanding of the workplaces that exist and the records that they expect are being kept at those establishments, that we will see 129,000 locations reporting their injury and illness data, 300 logs, 301 incident reports, and 300 A's. And among those smaller establishments, 20 plus or 20 to 249, they expect to see 440,000 new reports of injury and illness data that they were not collecting annually historically. So, almost 600,000 sets of injury and illness data are going to be reported under this new rule that OSHA did not historically have. The other really sort of remarkable data point on this is that OSHA was essentially receiving no 301 incident reports. 301 reports, the so-called detailed incident reports, were not required to be submitted through the annual surveys. And based on estimates that OSHA produced in this rulemaking, they are expecting to receive more than 1.3 million 301 incident reports through this rule. So that is a sort of astonishing volume of records. To think about what this agency could possibly do with that is something to think about. And I don't think there is anything productive that they can do with it. So we'll talk about in a second why they are requiring us to make all these submissions if they don't have the resources or the manpower to do anything productive with it. So logistically, how is this going to work? The data is going to be submitted electronically through a secure website that, so far as I know, does not exist yet. And this is making a lot of people nervous, the idea that it is secure, because you're sharing a tremendous amount of data with OSHA, with the government. A lot of it, I think, would be considered sensitive or personal information about your employees, perhaps even personal health information about your employees. So there is some anxiety, some angst about how secure this website really will be. And then the next step is that OSHA is going to attempt to scrub the employee identifying information. And the major way that they're going to do that, the primary way they're going to do that, is before they publish it, and that's the next big step here, if you didn't know that already, that OSHA is going to be publishing this data online for all the world to see. But before they publish it, they are going to remove the employee name column from your 300 log, from the submission, and then run some other electronic program to look for where employees' names might appear in other areas of the record-keeping logs, like the 301 incident report, or some other record or some other part of the record-keeping process. I think that is a risky prospect, that whatever software system OSHA is going to use is going to adequately and accurately remove employee identifying information. And then it also ignores the fact that simply removing an employee's name does not necessarily remove employee identifying information. If you have a workplace that has, for example, one security guard or one forklift operator or one type of maintenance person, and the injury described is an injury that could only have occurred to or in connection with the work of a security guard or a forklift operator or a maintenance person, then people are going to know who it is. So there is not going to be employee identifying protection simply by looking for and scrubbing employees' names and just hoping that a computer program gets that right. So I think there's a great deal of risk here that employees' personal information is going to be produced online. This is one of the reasons. We'll talk about this a fair amount today, about how this rule discourages, it discourages recording of injuries and in some ways discourages reporting of injuries. And OSHA recognized that after industry and everyone raised significant negative comment about the rule, that it discourages reporting and recording. And they try to address that by incentive programs and challenging incentive programs and challenging drug testing and all this other stuff that Amanda's going to talk about. But what they don't realize is employees don't want this information online. And as much scrubbing as OSHA is going to do, there's going to be a great deal of angst about having your personal health information, your injury information published online, and none of the efforts that OSHA has made to address retaliation do anything about the fact that employees do not want their personal information on some government website, and this effort to scrub, I don't think will adequately do that. But that's something to think about here. The next step in this process is that OSHA will publicize employer-specific information. So they're going out of their way to try to extract any employee identifying information, but they very much want to identify employer identifying information in the way they publish this online. And it will be published on OSHA's website without context. And without context, what I mean is, if there was employee misconduct that caused an accident, or an act of God, or drug and alcohol abuse caused an accident, those things are not generally found on your 300 log. If there was a defective a piece of equipment that was provided by a different manufacturer that you're working with at your plant, and that machine caused an injury, it's work-related, it meets the criteria for recording, it gets recorded, it's going to be published online, regardless of whether there's anything the employer could have done to prevent it, whether there is any cause or blame to be associated with the employer. There it is, tied to you as the employer. So why would OSHA do that? This is why OSHA is doing that. This is David Michaels in the press release announcing the new final rule. Our new rule will nudge employers to prevent work injuries to show investors, job seekers, customers, and the public they operate safe and well-managed facilities. So the idea here is this fits right into the regulation by shaming philosophy that this agency has advanced over the last 7 years. And the idea is that if we publicize and badmouth and defame employers about workplace safety and health issues, that they will change their conduct and they will improve their safety and health program. And that is, in my opinion, the only reason why OSHA has advanced this final rule. It is to, as they say now, nudge instead of shame, but that is the same effect. That if we publish your injury and illness data, you will be embarrassed, you will be harmed, your business will be harmed, your investors, prospective employees, your customers will make decisions harmful to your interest based on this data, so you will try to improve the data. And there are so many problems with that thinking, especially tied to this lagging indicator, injury and illness record-keeping data that makes no accounting for fault or blame. It's just not a good policy. So that is why OSHA has advanced this rule and why they are publishing the information online tied to individual employers. I see we've got a pile up of questions here, so let me take a break here and look at some of these questions and see what we've got. We have contractors on site during certain times during the year that are conducting maintenance work. The number of contractors on site would push our peak number of employees over the 250 threshold. The contractors are not supervised by our location and would not typically track their hours or injuries on our OSHA 300 or 300A. That last sentence is exactly how I was going to answer the question. To me, the relevant number of employees, the 20 to 249 or the 250 plus, that count towards those thresholds are the employees whose injuries belong on your log, or the injury to whom you have an obligation to report to OSHA if it meets the reporting criteria. And that, by definition in the record-keeping standard, are the employees who you supervise on a day-to-day basis. So if you have contractors on site that you're supervising on a day-to-day basis, you're giving assignments, you're providing tools, you're providing the PPE that they wear, you're supervising their work activities, those employees count towards the 20 to 249 or the 250 plus. But if they are employees of another contractor who has its own supervisory presence on site, who is supervising their work activities, who's directing the means and methods of their work, who's providing the tools and the PPE, and their injuries would belong on that contractor's log and not yours, it is my view that you do not need to count those employees towards the 20 to 249 or 250 plus threshold. Let's see. Another question here is we use our own accident report, but we have to start using the 301 incident report. I've gotten that question a few times also. The way this is going to work, to answer your question quickly, the answer is no. I don't think you're going to need to change your process at all, because this is not going to be a matter of mailing in the form that you use or scanning and PDFing and uploading the forms that you use. What's going to happen here is that you're going to be populating fields in some database, in some website that OSHA creates. So if you're using a different record-keeping form and you're allowed to use alternative 301 forms if they have all the required information, what's going to happen is you're going to have to take the data from that form and rekey it into OSHA's database to submit it to OSHA. Now, what you may end up doing for practical purposes, if you find that this is too burdensome, and we think this is extremely burdensome, is that there's going to come a time where if you're not already on an electronic record-keeping system already, that it's probably going to make sense to move to that type of system. And I've really struggled here to give sound advice to my clients about this, because a lot of my clients are still on paper record-keeping, and I know that it's going to make sense to move to an electronic record-keeping form, but we don't know what's going to speak to OSHA's database yet. So I think it may be premature to start to implement an electronic record-keeping system if you're not already doing that, because it would be a shame to do that, to invest money in some new software, some new electronic system, and then have that system not interact, not interface effectively with OSHA's system that hasn't been introduced yet. So I think it's time to start thinking about a move to electronic systems, but it may be premature to actually adopt one, because we don't know whether the one that you adopt will facilitate you just sort of clicking a button or dragging and dropping or doing something that makes your job easier in submitting this data to OSHA, because I do think there's going to be a significant burden in doing that. But in answer to your specific question, it doesn't matter what piece of paper you're using or what format you're using right now, because OSHA is not going to accept or take the format you're using. They're just looking for the data from those forms. All right. There's another question here. Is there any chance that this rule does not go forward in its current state or not go forward at all? There's no chance. This is not a proposed rule at this point. This rule has been published in the Federal Register. It is technically effective in August, with some deadlines that kick in the early part of next year. One of the things that I would have said, there was a possibility under the Congressional Review Act that so-called midnight rules that are pushed through at the tail end of a president's administration, can very easily be killed by Congressional Review Act scrutiny, as opposed to requiring additional rulemaking or full legislation. There is a way to very expeditiously defeat a new rule. What the agency did here, and you'll notice that this rule came out, it was either the same day or the day or two before the new overtime rule that the Department of Labor put out. That's not a coincidence. These rules were put out just early enough that they are outside of the scope of Congressional Review Act scrutiny. So, unless there is a new administration, and I shudder to say it, a Trump administration that does not care for this rule, and OSHA engages in a rulemaking to undo this rulemaking, I would say this rule is done, and we are going to be living by this rule for the foreseeable future. Let's see, another question about the alternative forms to 301. All right, I think we've addressed all the. Well, no, a few more here. I guess a lot of people have a lot of questions about this rule. That's good. We have multiple establishments, but none have more than 20 workers. Therefore, we would not have to submit any information to OSHA. That is correct. If you have, it doesn't matter what your total corporate-wide employee count is. It's establishment by establishment. So if each establishment is fewer than 20 employees at peak employment, and that's going to be the key there. And I've seen, we've done this analysis with some of our clients where we've gone back a couple years to see how the rule might apply. And we've seen instances where the rule applies in 1 year but not the next. Employee count dips at peak employment from 22 to 19 from 1 year to the next, and you only have to report in those years that you meet the criteria during that calendar year at some point during the calendar year. There's a follow-up question about whether this rule, how can this rule go through without industry comment? It did. This rule was introduced back in 2013. There was a comment period. Amanda will talk a little bit about the process. This is an interesting rule in that the comment period was reopened to make the rule even worse. But there was industry comment. We submitted comments on behalf of a couple of trade associations, and here it is. We're stuck with it now. There's actually one other possibility. Somebody does raise the point that it's not just Congress that can attack these rules. It is very possible that some industry stakeholder could file a lawsuit to challenge the legality of the rule. And actually, I do expect that that's going to happen. I've heard rumblings from, Chamber of Commerce and others that challenges will be filed. If that's the case, we're going to see those within probably the next couple of weeks. This is going to be a tough one to challenge. OSHA does have pretty broad authority under the record-keeping rule to require employers to keep records and to require employers to submit records in certain circumstances. So we think they're going too far here, and that will largely be the basis of the challenge. And then likewise, we think there is a gross imbalance between value to safety, of which I'm not sure there is any, and burden on employers, and I think there is significant. So that is one good point raised here by one of our participants, that the only way, I suppose, that this rule could be killed would be by legal challenge, or amended, would be by legal challenge, and I do expect that will happen. I'm just, not holding my breath on the outcome. All right, so where do we dig back into the slides here? Here are some of the things, and this is interesting. I've sat with some of my clients and talked about, what are the potential adverse impacts, and you see I've listed them here, and I'll cover this, but just going back to Dr. Michael's comments when the rule was finalized, I mean, they were very aware of this. These are not indirect consequences or unintended consequences, so to speak. He's talking about investors, your bank, your small business loans. He's talking about job seekers, prospective employees, current employees. He's talking about customers, both, from a consumer standpoint and those that you do contractual relationships with, and the public. So he's already, OSHA is very much aware of how this rule is going to harm employers, and this was the list that we put together thinking about it with some of our clients. This rule is going to discourage consumers from doing business with them. This is, your federal government, we've talked about it in the context of the Severe Violator Enforcement Program and the nasty press releases and things like that. The federal government, the agency responsible for safety, saying you're a bad actor with those programs, and here publishing online all of this injury data without context. Your competitors are going to be able to push these numbers out in front of people. Consumers will, go access these records and say, well, I've got a choice to do business with this company or this company, and this company has, more recordable injuries. Whether that has anything to do with the employer safety program or any of those could have been prevented, it could cause consumers to make different decisions. Thwarting contracting opportunities with customers. We're already dealing with a lot of employers have to bid on contracts and present some of their OSHA history and some of their injury and illness record-keeping history to bid on those contracts. Now all this information will be public, and I think it will be used even more by contracting parties to make decisions about who to do business with. I think this probably more than anything provides a significant amount of ammunition to organized labor, either to target individual establishments, target individual companies for organizing campaigns, or using the data at the bargaining table to push for, additional staff and push for, whatever they're pushing for at the bargaining table, and using this as leverage in that process. We think that this data, obviously could have the impact of scaring off prospective employees or losing current employees, eliminating access to small business loans. Banks, this is another resource that banks can now go and look at and decide whether they want to do business with an employer. And again, there's no context with this. This is, no fault, no blame record keeping, but it's going to be used purely as a negative. I mean, the idea that, from the beginning, injury and illness record keeping was not intended to be a metric or measure about how employers are performing. It was supposed to be, very broadly defined. Things that end up on your record-keeping logs are often very minor, but they were there to help you make decisions about how to improve your workplace. And now they're going to be used in a harmful way. And then obviously negatively impacting insurance coverage and rates as well. Let's a couple of questions here I'll address real quickly. Will they be collecting hours worked for the site to give it some context? The answer to that is yes. Every employer who's required to report here, you actually see on this slide, are required to submit their 300A forms, and hours worked, if you're filling out your 300A accurately, would be on that log. So it certainly will give quasi-context in the sense of if somebody's calculating rates based on the data that they're seeing online. But if you are a large employer with many, millions of hours worked, but you still have, dozens of recordable injuries as compared to a smaller competitor that has fewer injuries, even though your rate might be better, this is going to be reviewed by, non-safety experts. A consumer who's deciding what, grocery store chain they should send their business to is going to see that one guy has 50 injuries, or one employer has 50 injuries, another has 10, even if you're significantly larger, and even if these are, the result of something that the employer had no control over, they're going to be making decisions based on that. Let's see. And so let's talk a little bit about the reporting deadlines here. We are presently in year 2016, and everybody on the phone, if they are covered by the record-keeping standard, is keeping their 2016 300 log. And at the end of 2016 and the first couple of months of 2017, you'll be completing your 300A annual summary. So for the injuries that are happening this year, and they're being recorded on your 2016 log, and then translated into a 300A, only the 300A that represent 2016 injuries are going to be submitted to OSHA, and they're required to be submitted by July 1, 2017. So for the first year, OSHA is not requiring larger employers to submit the 300 logs, the 300As, the 300 logs or the 301s. It's just 300As in the first year, and you have until July 2017 to submit that data. And we still haven't seen the database that OSHA is going to be using for this, so perhaps the extra time there is to allow OSHA to continue to advance the development of this of the database itself. So for 2017 injuries, that's when, for the larger employers, the 300 logs and the 301s will have to be added into the mix. So if you're 20 to 249 employees covered by the rule, you submit your 300As, again, by July 1st of 2018, but now the larger employers have to also submit their 300 and 301 data at the same time with their 300A by July 1st. Then once you get out into 2018 injury and illness record keeping, for those for that year and every year thereafter, the new deadline to submit is March 1st. So you will, still it sort of fits in with that timeline of when you're completing your 300A and posting it at your facility. It's after that, but you get a little bit of extra time to then submit it to OSHA's database. So 300 logs, 300As, 301s for large employers, March 1st every year thereafter, 2009 and thereafter, and 300As for the smaller employers have to be submitted. One of the other, there's a question about this, but I was getting ready to mention it anyway, is that the state plan states are required to adopt this rule, and they were given 6 months to do so. And so since they were given 6 months to do so from May 12th, that means by the end of this year, the state plan states are supposed to have adopted the rule, which means by July 1st, 2017, every state will be required to collect or accept or have their employers submit their 300 A's by July 1st, 2017, and then for larger employers, their 300 logs, 301s, and 308s beginning in 2018 and thereafter. The one sort of potential difference that the states have, or that the flexibility that federal OSHA has given to the state plan states, is that they can either use the same database that OSHA is building, that federal OSHA is building, for its own collection purposes, or the states can create their own submission methodology. My expectation is that most of the states will just use whatever system federal OSHA sets up. But whether you're Cal OSHA, Virginia OSHA, Tennessee OSHA, whatever, the state plan states all must adopt this policy, this requirement, by the end of this calendar year, so that by July 2017, every employer in the country, even in the state plan states, will be submitting their 300 A's into the agency. Let's see. There's a question here that says, I know this has been asked before, but looking for clarification, so my answer wasn't clear. I'll do better this time. I am a company with 2,500 employees, where there are only about 20 establishments with more than 20 employees on site. This is a very good question. This is a good speaking of clarification. Are those 20 establishments where we have 20 employees or more on site the only establishments within my company that must do the reporting, or do we report for all of our employees across the entire country in one company submittal if we have some that meet the threshold? So the answer is the only establishments about which the data for which you have to submit are those establishments that meet the criteria. So if you have 100 establishments, but only 20 of them meet the threshold for reporting submission to OSHA, you only have to submit for those 20 establishments. The other 80 establishments do not need to submit. One thing that OSHA has said is that you are free. First of all, you can voluntarily submit any data you want. OSHA is more than happy to accept data from an establishment that's not covered by the rule. Obviously, I don't recommend that, but that's an option that you do have. The other thing that OSHA has said is that you can have the submission occur from a centralized location, but what it is that centralized location must be submitting is establishment by establishment submissions of data. So if your company headquarters collects all the 300 logs and produces all the 300 A's for your various establishments around the country, you can have that one centralized person at headquarters handle the data submission, but they need to be submitting them individually by establishment and including just the hours worked, the injuries for those individual establishments, and identifying what establishment it is that they're submitting for. But this is not a case where if some of your establishments qualify, the entire company has to submit. That's not how it works. All right, so that's I think I've gotten through my chunk of this. I'm going to hand it over to Amanda to talk about some of the other elements of the rule.
Good afternoon. Eric's been talking about or touched upon many of the stakeholder criticisms that have been discussed during this lengthy rulemaking process. And one of the most common ones, or one of the loudest ones, has to do with the reason OSHA is coming forward with this rulemaking. Throughout this whole process, OSHA has not really identified why they need to have the information that they're going to have at their fingertips as a result of these electronic filings and the additional submissions of the record-keeping logs. They haven't suggested it's going to be used for OSHA inspection targeting. They haven't identified a safety gap that it's going to be filling. So it's one criticism that has been reoccurring throughout this entire process is really OSHA's motive for collecting this data, since they've not clearly identified what it is. It's hard to imagine what the real safety value is. Another common stakeholder criticism has been the actual increase of underreporting. A lot of the employer community has actually indicated to OSHA that this will cause underreporting. If there's going to be a close call with regards to whether an injury goes on the OSHA log, they're probably going to err on the side of being more conservative and leave it off so that information isn't put out there in the public realm on the website. So that's been one criticism as well. It's going to harm the relationships of prospective employers and merchants and so forth, individuals that companies deal with. Could go even down to financing and getting business loans and going to the bank and going to apply for a loan. They pull up your occupational safety and health record and your injury and illness data, and they put that into a factor or consider that on whether or not to grant a loan to a company. And another one that has been preeminent throughout this entire rulemaking process is the no-fault injury record keeping. OSHA has long held that the record keeping regulations are no fault. Basically, that means there's not a fault determination with regards to whether it's the employer's fault or the employee's fault. There was a presumption that if it happened in the workplace or during work hours and it did not fall into one of the enumerated exceptions, it had to be recorded on the injury and illness log. And so by putting this information out there to the public, it is undermining that no-fault injury recording process that's been in place for so long. And for what reason? We're still not sure, as I touched on the first bullet point. And then also, the record-keeping rule substantially underestimates the time and financial burdens that's going to go into complying with this new record. I was looking at the notice or the preamble to the final rule this morning, and OSHA, for all companies to come in compliance with this regulation, is estimating $15 million. They state that employers already have this requirement to do record keeping, and a vast majority of them are already doing it electronically. But they don't take into account on, whether or not those systems are going to meet up with the OSHA portal for submitting this information and the ramp-up time to learn what the regulations are and the new regulations are and to comply with them. So a very dramatic underestimating of the time and the financial burdens that employers will have to undergo in order to comply with this regulation. Moving on to the next slide, this rule has had a bit of a history. It was initially proposed in 2013, and it really focused at that time on the electronic data submission portion. And a lot of the criticisms that we just went over were brought up by the employment community. OSHA went through a comment period. They actually had a couple public meetings on this, and they were getting a pretty big pushback with regards to opposition to the electronic filing. And so at one point, I guess it was maybe 2 years ago on August 14th, they got approval from OMB, the Office of Management and Budget at the White House, to reopen the rulemaking record, and I think there was a lot of relief within the employer community thinking that, OSHA's finally heard our voice. They're going to make some modifications to this rule. Well, that's not exactly how it turned out. OSHA decided to go the other way in regards to the criticisms that they were hearing. They decided to basically expand the rule and put some anti-discrimination provisions in it, put a requirement in the rule to have a policy for reporting injury and illnesses, and going as far as to put a provision in there for whistleblowers. So that was opened in, the record was opened, additional comments came in, and then the final rule that Eric was just talking about was published. And as part of that final rule, there were some additional details that were not in the initial rule back in 2013. It expanded past the electronic submission portion, and it's now requiring employers to develop and implement their own illness and injury reporting policy. Basically, it means that employees can report any workplace injury or illness. Interestingly enough, was looking at this requirement this morning. It's actually very vague. It's not actually, OSHA is not stating that it has to be in writing, but certainly with many things with regards to OSHA, if it's not in writing, it either didn't take place or it doesn't exist. So certainly a recommendation to develop those policies in writing. and it cannot discourage or deter employees from reporting their injuries and illnesses. And some of the examples that OSHA provided with regards to discouraging were multiple steps in going through the reporting process, late reporting, if there was a penalty or some sort of employee discipline related to late reporting, say not reporting it within 24 hours of the injury. Those things OSHA would recognize as discouraging reporting and would issue a citation for noncompliance with the requirement to have that policy that sets forth a fair and undiscriminatory practice for reporting those injury and illnesses. As part of the rule, OSHA also expanded it to require employers to inform employees about the procedures for reporting, the right to report, and the protections that they have from reporting, basically that the employer is not allowed to discriminate against them based on the reporting of workplace injuries and illnesses. And was going through this provision this morning, and interestingly enough, it looks like all three of these notification provisions can be satisfied. OSHA's got some guidance out there indicating that as long as you post a OSHA poster, which is available on their website, it's the one that from 2015, so it's a more recent one, not the one that you typically see in the workplace. But as long as you post that poster, you will have met the obligation to inform employees. So that's just one additional reason. If that poster or there's not a process in place for otherwise notifying employees, OSHA could issue a citation under this new rule. Going on and talking a little bit more about the policy, OSHA now has essentially a new way to enforce whistleblower retaliation conduct by the employer without having a whistleblower. Typically, the whistleblower has been an employee who would contact OSHA and indicate that they feel as though they've been discriminated against, and they had to file that complaint within 30 days of this being discriminated against. And then OSHA had a mechanism and actually has their own office that does the investigation for whistleblowers, and that would be a violation of the OSHA Act 11C. So OSHA now has a new tool in their arsenal which would allow OSHA to move forward with a retaliation claim without having a whistleblower. They basically look at this and think that the employees are being discriminated against, and so that they don't have a voice and won't always use that voice to contact OSHA to initiate the process that was set forth by the OSHA Act. So now OSHA can independently start the investigation to determine whether or not any employees have been retaliated against for any safety and health conduct, particularly with regards to injury and illness reporting. So that is something that is new, not a lot of guidance out there on it. Certainly going to be an interesting new to see how this is going to be enforced, and hopefully there will be some more guidance material that OSHA publishes on this. Some of the reasons that OSHA could issue a citation for retaliation, like I mentioned before, having a policy that requires or disciplines employees for having late injury reporting. They give examples with regards to ergonomic issues and back issues, and employees reporting it after a time period, recognizing that it might be back strain due to the workplace, and saying that that gives an example why these late reporting requirements are not effective or should not be allowed in the workplace. Also, too, disciplining employees for violating vague work rules. Work carefully or maintain situational awareness. They're looking for very specific requirements and very specific procedures. One of the other big controversial aspects about this is post-incident drug testing. In some places, some employers have it as a common practice. Anytime that an employee is injured in the workplace and they go to a medical provider, there's a drug test. OSHA is now saying that blanket drug testing is not allowed. It is only really permissible. There's certain circumstances where it could be, but most frequently it would be in the context of where the state or some other federal provision requires that drug testing. We'll talk a bit more about that in a moment. and then safety incentive programs, which have been a major focus of OSHA throughout this entire administration starting in 2009. And one of the slides, we'll talk about that here in a moment in more detail. But with regard to this new whistleblower retaliation conduct, the potential citation that an employer could receive, not only are they going to be on the hook for a serious citation, which we expect to go up to roughly $12,500, or willful or another classification of citations, they could also, the abatement could be reinstatement or back pay for that employee. So we're looking at, a pretty costly abatement for this new requirement that is not very well defined by OSHA.
Amanda, there's a couple of good questions here that are tied to the topic that you're covering right now, and they both sort of relate to this same issue of late injury reporting. And the question one is, I've heard that there can't be a time requirement on reporting injuries or illnesses. Now, that's not quite right, but I know exactly why you've heard that and why industry is concerned about that. There are two pretty controversial 11C actions that OSHA is advancing right now, retaliation actions that OSHA is advancing right now for employees who are disciplined for not reporting. The company had a requirement for, I think it was report within 3 hours or report within 1 day, certain types of injuries. And there were two injuries that were not reported. I think both of which, at least one I know for sure, was a splinter, a bad splinter in the finger. The employee pulled it out on his own, didn't feel like it was a big deal, didn't report it. Then it became infected a day or 2 or 3 days later and became an injury that had to be medically treated beyond first aid. Where if the employee had reported the injury timely within the employer's required policy, it could have been addressed in a way that would have prevented the injury from getting worse and becoming recordable. And for whatever reason, OSHA has taken this up, and they are advancing the cause for that employee and saying that the employer's policy of requiring reporting within, I can't remember whether it was within 3 hours, 6 hours, or 1 day, that was unreasonable. And what it does, in particular, what the discipline for not reporting within that short window of time does is discourage employees from reporting at all. Because if they miss that 3-hour window or 1 day window or whatever, and they know they're going to get disciplined if they report this injury to the employer, then they're just not going to report it if they miss that window. So OSHA, that's what their concern is. So they have said that you must have reasonable time frames for reporting. What you can't do is create a policy that creates a burden or an obstacle or discourages employees from reporting. So there's a question that says, what's a reasonable time frame? I wish I could tell you. I think that OSHA has represented that 1 week to 10 days or something like that would be a reasonable time frame. I disagree with that from a safety standpoint. I think that's incredibly irresponsible, especially since the record-keeping rule requires you to get the injury recorded within 7 calendar days. It seems that any period broader than that would be unlawful. And I think that the very case that OSHA is advancing shows you that a policy that doesn't require reporting within a day, I think, is a bad policy because injuries can get worse. Injuries that could have been treated and prevented from becoming worse can get worse, and it seems illogical to me that OSHA would be prohibiting employers from doing that. That's the general view on those things, that OSHA is looking for, rules that don't discourage the reporting. There's a point being made here. Let's see. If the policy states immediate reporting, but there's no discipline if reporting is late, is there still an issue? That's a really good question. I mean, OSHA is going to be looking at your policy to see if it discourages late reporting. And so if you have examples of late reporting where there hasn't been discipline, I think it would be hard for OSHA to demonstrate that, A, that there has been any discouragement, and B, that there's been any retaliation. So I think the answer is probably that would not be an unlawful policy. But, we know that OSHA is going to be looking at these things even without a whistleblower, so it's possible. Even without an employee who says he was discouraged from doing something. If you have a policy that says that, I think it's risky to have your policy say that. And then there's another question here that I'll let Amanda address both of these questions about what these drug testing and incentive program policies mean, and here's a full slide on that.
Okay. Going back to the drug testing, OSHA comes out and says blanket post-injury drug testing policies deter proper reporting, and that they would be considered discriminatory. Basically, an employee would not report an injury if he knew that he was going to have a drug test and had drugs in the system. OSHA has basically said, unless there's a law, whether it be state or federal, that requires drug testing, that would not be discriminatory because it's already required by another statute. So that would be one of the permissible ways that the drug testing could take place. And then secondly, OSHA is saying that when there is a situation when an employee's drug use is likely to have contributed to the accident and for which a drug test can accurately identify impairment caused by drug use, that would also be permissible. And Eric and I were talking earlier about what you would have to establish in order to drug test and not have an issue with OSHA afterwards. And it's a pretty high standard with regards to that. I mean, if a forklifter is stumbling or slurring their words and they get in an accident and you have witnesses beforehand testifying to their state of mind beforehand, I guess that would be an acceptable drug testing opportunity to do a drug test. But then the latter part of this sentence, drug testing that can accurately identify impairment caused by drug use. We're not aware of any such tests that can do that. So it just really seems like a very high standard that OSHA's put forth here. Nearly impossible to do any sort of drug testing unless it's required by some other law. So it is interesting provision within this regulation. And once again, other than what OSHA's put out in the preamble, not much guidance on this, but could be that they do look or institute or publish them before it finally goes into effect in the beginning of August of this year. Also on this slide, we talk a little bit about safety incentive programs. OSHA has had a strong dislike of safety incentive programs since this administration came into place. And up until this point, they've really not had an enforcement mechanism that they could express that dislike. The only time that you really saw that there was an issue or OSHA was able to change employer behavior on this front was through cooperative programs such as BPP, employers going for their recertification for BPP or applying for it for the first time, and OSHA saw that they had an incentive program that employees who did not report an injury or illness their names would be entered into a raffle and they could potentially win a TV. OSHA didn't like those sorts of practices and were requiring employers to remove them from their safety and health programs before they would approve them for the cooperative program. Now, under this regulation, OSHA does have an enforcement mechanism to require employers to abandon those programs. We've actually got a lot of questions on these incentive programs. One of the more interesting questions that we've had is it seems to be pretty clear-cut anytime that discouraging an employee or there's an adverse action or disqualifying the employee from some sort of benefit because of reporting an injury and illness, that would be prohibited under the new regulation. But what about the situations where management compensation is related to injury and illnesses? A little bit more, certainly murky. OSHA has not really put out much guidance on that front. So this is definitely something we're looking forward to getting some more guidance from on OSHA. Just bare bones guidance so far. And the interesting thing is these provisions actually go into effect August 10th, 2016.
Amanda, just to add one point to this, I mean, the example that we have here and the image on this slide came straight from OSHA's website. when they're talking about this new rule and talking about these incentive programs that they discourage. But in this instance, talks about, hey, win a car if we keep our injury rates low. I suppose there is a rationale there that an employee might make a decision about reporting an injury if it could cost them a car. But the example that OSHA uses most often, and whenever they give speeches about this, whenever they talk about this, they talk about the pizza party. And that is the prime example, that if you offer a pizza party to your crew or to your workforce or to your establishment, if we go a month or 6 months or a year with no recordable injuries, then that is an unlawful incentive. That pizza party is going to discourage employees from recording an injury. And I just think that lacks credibility. I'm incredulous about the idea that an employee is not going to seek medical attention. He's not going to report something that the employee has identified to the employee as a mandatory thing to do. You must report these injuries to us, and they're not going to do that because of a pizza party. I just think lacks credibility. But OSHA has been on a rampage about this. There was the Fairfax memo that went out, to all of the regions, all the area offices that said these are unlawful practices. A pizza party in exchange for not reporting an injury is a terrible thing and should not be allowed to go forward. As Amanda mentioned, if you're a VPP site, a VPP employer, you may not continue to participate in that program if you have a pizza party type of incentive program. There were 11 C actions threatening the legality of that, and now a rule that basically says these types of incentive programs are unlawful. To me, it's just this sort of 7-year assault on the pizza party is irrational. I just don't believe that there is any evidence that employees are not reporting injuries because of that, or small gift cards, or things like that. And I just don't see this as a real problem, but it's now a citable offense in OSHA's regulatory portfolio. So something to be careful about.
And, talking about these policies with regards to drug testing and incentive programs, which are all part of, having a reporting policy that does not discriminate, all of those requirements go into effect on this August 10th, 2016. So that's when you have to have the reporting policy in place. And you also have to have your system for informing employees of the right to report workplace injuries and the right that they have to be not to be discriminated against for that reporting. So those are the requirements in this new standard that go into effect just in a couple months. I'm going to turn this back over to Eric to finish out the presentation.
Sure. We went fairly long on that rule, and understandably that's the rule that is on everybody's mind and is the most controversial to deal with, and it's coming due very soon, or your actions required under this are coming due soon. So I'm not going to spend a lot of time on this other rule, and I won't be offended if a bunch of you drop off, but there is another injury and illness record-keeping rule that is making its way through the rulemaking process, and this is OSHA describing it again, calling it the clarification of employers' continuing obligation to make and maintain an accurate record of each recordable injury and illness. And I love the idea that these rules are all clarifications. This is, in fact, not a clarification. This is a very significant change in the law. And I think this is an unlawful rulemaking, but OSHA is pushing forward anyhow. There is a statute of limitations set forth by the OSHA Act that says, OSHA must cite employers for violations within 6 months of the occurrence of the violation. The D.C. Circuit, in a case called Volks Constructors, said that the occurrence of a violation as it relates to injury and illness record-keeping problems, either not recording an injury on your log that should have been recorded or recording it wrong, putting the wrong category that made it recordable, not describing it adequately, whatever the reason is, if you do not adequately record that injury or record it at all within within 7 calendar days, which is required by the record-keeping standard, the violation occurs at the moment the day begins. So at the beginning of the 8th day, you have committed a violation. And the statute of limitations in the OSHA Act says OSHA must cite that record-keeping violation within 6 months of that day. So it's 6 months and 8 days to cite an OSHA record-keeping violation. There is another requirement in the record-keeping standard that says you must keep your record-keeping records for 5 years, meaning, we take down our 300A form, we keep our 300 log and our 301 reports tucked away in a little file cabinet in my HR office, and we leave it there for 5 years, and then we can discard them. OSHA had historically viewed that 5-year retention requirement to create a continuing duty, that your duty to correct a 300 log that didn't have a recordable injury that should have been there, or to correct a recordable injury that wasn't recorded accurately, that you have a continuing duty during that 5-year retention period to update it. So the D.C. Circuit examined that question and decided in a very clear and concise way that that's not the way the statute of limitations applies in record-keeping cases. There is no continuing obligation to record or to update during the 5-year retention period. It is only a retention period. It is only a requirement to physically keep the log. And the obligation to record and the obligation to maintain are two distinct requirements. So that was the D.C. Circuit, a federal circuit, federal appeal court that has jurisdiction over every OSHA case in the country. Every case can be appealed out to the circuit where the workplace exists, or to the D.C. Circuit. So the D.C. Circuit sets nationwide OSHA precedent. And the D.C. Circuit said, you've got it wrong, OSHA. The decision was based on, the majority opinion was based on the fact that the OSHA Act does not permit the interpretation that OSHA was trying to apply. That the legislation passed by Congress said there is no continuing duty for these instances. An occurrence of a violation is when the record keeping should have been done or done right, and that starts the clock. And so, here you've got the D.C. Circuit saying that legislation by Congress means this. Obviously, the only way that that can be changed would be to appeal that case to the Supreme Court or to have Congress change the legislation. But what does OSHA do instead? They propose to amend the record-keeping regulations to clarify that a continuing duty exists. So they're trying to change, the D.C. Circuit's opinion of what a congressional congressional statute says by rewriting a regulation. I think it's pretty obvious that that is not a lawful way to change the statute of limitations for record-keeping rules, but it's a lot easier, so that's what OSHA is trying to do. There are major problems with this. I think it challenges our 3 branches of government checks and balances system. It attempts to overturn a D.C. Circuit opinion without appeal to the Supreme Court. It circumvents the OSHA Act's legislative statute of limitations and attempts to do it by regulation. It creates a broad new standard for ongoing or continuing violations. They're doing this by regulation right now as it applies to injury and illness record keeping, but what they're really doing is redefining what is a continuing violation. And if this is permitted, then I think there could be a broad expansion of other types of violations that might be considered continuing violations that would allow them to cite other violations that happen, for incidents or injuries that occurred well in the past. And the other thing that this does, really in conjunction with the new electronic submission rule, is it makes OSHA's enforcement of record-keeping violations much, much easier. And I will admit, it was extremely challenging for OSHA to find and cite record-keeping violations within 6 months of when an injury occurred, within that 6-month and 8-day period, because unless they just happen to be at the workplace, it's hard to find and cite those things. Now with the new reporting rule that single hospitalizations get reported, and with the electronic data submission rule that will kick in July of next year, you combine that with a 5-year statute of limitations, and I think record-keeping enforcement could be through the roof. So I just zipped through that to make sure that I didn't take up your entire afternoon. But I would encourage everybody to check out our OSHA blog, the OSHA Defense Report, www.oshadefensereport.com. We've written about both of these rules extensively and about all kinds of other interesting and exciting OSHA issues. And I would encourage you to check it out. I'd love to know that someone other than my mother is reading it. So please get on there and take a look and write to us and let us know if you have any ideas for things we should be writing about. We'd be happy to do that. I'm going to take a look back here at some of the other questions that we've seen and try and address those real quickly, and we'll go from there. See if there's any other questions. Let's see. There's a question about slide 20, whether all of the elements of slide 20 are addressed by the reporting of the OSHA poster. Inform employees. And so I think the answer to that question is yes, and it's really interesting. Amanda and I were talking about this today, because the new poster, and this is, you're actually not legally required to post the new version of the poster. But if you do, OSHA has put out guidance that says it satisfies these requirements. What's interesting about it is that the poster does not actually address these subjects. So it's hard to understand why. It addresses some of them, but not all of them. It's hard to understand why simply posting the poster would satisfy the requirement, but OSHA has suggested that it does. I think it's, perhaps a little risky to rely only on that, on the poster to satisfy these. I think it makes sense to evaluate and update and inform employees about your reporting policies and about the right they have to report and to report without retaliation. I think having something written, this is like any other OSHA enforcement context. If it's not written, it didn't happen. The poster will be, obviously, that exists. That's something you can point to. But I wouldn't be comfortable just doing that. But OSHA has suggested that that is an acceptable way to address that. Let's see. A lot of questions about the slides and a copy of the recording. I hope to turn that around to you all within the next 2 or 3 days. So, certainly by the end of the week, you should get an email from me with a copy of the slides and a link to the recording. So just to clarify, these are the tricky questions about establishments. If my company has locations with 20 to 249 employees but does not fall into the list of high-hazard industries, does the e-record-keeping requirement apply? The answer is no, provided you don't hit that 250 employee threshold. If you are 20 to 249, but you are outside of the quote-unquote high-hazard industries, you do not have an obligation to report your or to submit your injury and illness data to OSHA. There was an earlier question, too, and I thought I had addressed this, but I do want to make clear that there is, in OSHA's just general record-keeping regulations, there is a list of NAICS codes that are excused from record-keeping generally. There's clothing stores, accessory stores, things like that. If you are not covered by the record-keeping provisions at all, it doesn't matter how many employees you have. It doesn't matter, basically, it doesn't matter how many employees you have. You won't have a duty to submit your data to OSHA if you're not required to keep the data at all. I think that is it. If I've missed some questions, I'll go back and double check and I can reach out to you, but always feel free to contact Amanda or me or any of our colleagues at Conn Maciel Carey. I'll put up our contact information. We're always happy to talk about these things. I find this fascinating, and the questions that I'm getting from people are fantastic about this rule, triggering, I don't know the answer to that. Let's go research this and learn more about this new rule. So the more we hear from you, the better informed we'll be. So we appreciate everybody joining us today, as always, and we'll look out for having you participate with us in our next webinar. So thanks for joining us again, and we will talk soon.